welcome to Deposition Survival Guide for New Attorneys. I'm Mia Wall, Vice Chair of BHBA's Barrister Section, and I am delighted to introduce our speaker, Tyler Pabujian. Tyler Pabujian is an attorney at Pana, Shea and Ravipudi in Los Angeles and focuses his practice on catastrophic personal injury and wrongful death cases throughout California and Nevada. Tyler has assisted in securing 8-figure settlements for his clients and is recently part of the trial team that obtained a nearly $49 million verdict from Van Nuys jury in the personal injury case of Hakimi versus City of Los Angeles. And now let's get started, Tyler.
Okay. All right. Good afternoon, everyone. This is a pleasure. So basically, this webinar is geared at some deposition tricks, planning, preparation for newer attorneys. We'll go over everything from preparing an outline towards strategic questionings, ways to use exhibits, and a little bit of a review process after you take your depositions. So I'm just going to share my screen. So let's get into it. Okay, so we're going to kind of tackle this one by one, starting with preparation. Okay, so when preparing, there's usually 5 things I like to keep in mind, starting with the witness you're going to be deposing, then about the issues that are going to go into that deposition, the types of exhibits you're going to want to use, and then from there, building your outline, and of course, knowing the law, so you're not trial during the deposition. Okay, so knowing the witness. You're taking a defendant driver deposition, maybe a PMQ, it's a third-party witness. All that's, of course, relevant into how you're going to prepare, what type of exhibits you're going to pull, etc. And you also kind of want to think about how they're going to fit in your case. In the sense, are they going to be good for you? Are they going to be bad for you? Is it going to be a more cross-examination type of deposition or purely fact-finding? Are they strictly liability witness, a damages witness, or both? And you're going to want to prepare accordingly, determining based on that. Okay. And again, knowing the issues, which, goes right on top of the type of witness you're going to be deposing. So, for instance, if this is like a disputed liability case and there's some argument about whether the light was red versus green, you're obviously going to want to spend a lot of time on that if you're taking the adverse driver's depo. You're always kind of gonna think about comparative fault when doing liability depots. Try to hammer out the other side's story of if they think anyone else bears any fault, the client bears any fault, or something of that nature. And as we'll get into when talking about your outline and preparing, these are all going to be headings that you either have questions ready to go or certain subtopics about these specific issues. And then same thing if it's a damages witness, whether it's a treater, maybe a paramedic, first responder, uh, you're going to just kind of tackle your outline the same way and trying to figure out, is one of the issues in the case whether the injury was related to the accident, maybe there was some pre-existing injury, and you're going to really want to kind of narrow these issues down and kind of keep them in the back of your mind when preparing so you can kind of boil it down into this is what I want to get out of this depo. I want to make sure this issue is covered. I want to make sure that I know everything this witness is going to say at trial about whether this accident, whether this injury was related to the accident, whether they think this light was red versus green. So you're not surprised at trial and you kind of know what you're getting into when you put them on the stand. All right. Once you kind of have those things in the back of your mind, who your witness is, what the issues are, start compiling your exhibits. Okay. And, there's a plethora of different types of exhibits from reports, personnel files, medical records, vehicle codes, photos of the scene, like surveillance, dash cam footage, even pulling up discovery responses, the notice of deposition where you requested documents, all that sort of stuff. I like to think like start big, put everything in a folder maybe that might be somewhat relevant into a deposition folder for that witness. And then as you're kind of crafting your outline, you can kind of narrow down which ones you're going to use. Or it's always great just to have everything kind of at your disposal, just in case something comes up and you want to pull it real quickly. And so I have here an image. This is, for a defendant driver depo. folder with the different exhibits that I would plan on using during that deposition. I have my outline, the Word document at the top, and then just all the various types of exhibits that I plan on using. Now comes time for the outline. So with building your outline, it's, really up to you how you want to craft it. Some people like just doing big headings with subheadings and then a couple bullet points under each one. And for instance, as opposed to writing questions or having very specific things after each question, it's really preference. However, you're going to want to set it up by topic. That really helps keep you on track. And you're going to start with the admonitions, which are just the ground rules of the deposition. And then maybe go into some background. And then, here I have liability and then the different sequences of maybe the accident or the collision, starting with pre-incident, the incident, post-incident. And under those subheadings, you can have tailored questions for each one, or again, just some sort of ideas that you want to make sure you ask. And again, it's preference. You can write your questions out one by one by one, group them by ideas. Um, like I said, no one way to do it. However, I caution not to get glued to your outline because a lot of times your witness is going to take you off of your outline and maybe go on a tangent, which could be relevant. And it's, fruitful to explore and beneficial to kind of dig a little deeper. I have Tom Hanks here. Life is like a box of chocolates. You never know what you're going to get. You ask some questions, it steers you one way, and then maybe you get some sort of omission that ends up being great for your case. So it's good to have the outline as structure and to follow it and to keep you on track, but don't be afraid to, if you hear something that the witness says, to kind of follow up, um, circle back with him, and then come back to your outline afterwards. And then the last thing I have here is knowing the law. Okay, there's, a couple things you want to keep in mind regarding the law of depositions. Okay. And this will kind of help you have some more confidence with opposing counsel or with what you can and can't do with the witness and stuff of that nature. And there might be a little more than this, but I feel like these are kind of the core themes to keep in mind. The first one being that the really only proper objections in a deposition that need to be stated to preserve the record are form of the question objections. And when you're deposing another party, the counsel can only instruct their witness not to answer based on privacy or privilege. Instructing them not to answer based on relevance or hearsay or something of that nature isn't a proper basis. And in some cases, that might happen where counsel kind of fights with you on the record and instructs not to answer. You ask him what his basis is or her, and they state relevance or something other than privacy or privilege. And in that circumstance, I think personally, best practice, don't argue on the record. Keep it brief, say, that's not a proper basis to instruct not to answer. However, I'll move forward and I'd like to mark the record here. And then you're going to want to follow up with the witness after you ask your question that counsel instructs not to answer on. You're going to want to follow and say, are you choosing to follow your counsel's instruction not to answer, or are you not answering for some other reason, like not understanding the question? This will help clarify the record if you do have to bring some motion to compel, if it's a really material matter that you need an answer to, that the witness did understand the question and the pure basis is counsel obstructing the deposition. That's the reason for him not answering. Okay, let's go. Bullet point 2, in the Emerson Electric case, that gave us the holding where you can compel the witness to mark exhibits, to act stuff out, to draw things. So let's say you have, an image of the scene of the collision, and you ask one of the drivers, where were you at the time? What lane were you in? You have them mark maybe with an X That's the lane I was traveling in. Okay, where was the area of impact? Draw a circle there. Okay, where was the other driver? What direction was he heading in? Draw an arrow in a different color. And, that's great because you can now use that exhibit in other ways, maybe show it to another witness down the road to see if they agree. Um, Obviously, when you're doing that, you're going to want to make sure the record's clear, what they're marking with what color. Uh, but this case, makes it a proper thing that you can have a witness do. And then we have the third bullet point, which is pretty important and should be discussed pretty early on in the deposition after maybe the admonitions, is that you're entitled to know everything the deponent used to prepare for their deposition, whether they reviewed the traffic collision report, whether they looked at any medical records, whether they looked at any discovery responses, anything like that. Even if their counsel showed it to them under this evidence code, section 771, uh, the deponent is authorized to tell you what they used to prepare for their deposition. And that's great because it helps inform when you go forward and ask your questions what they've already looked at versus what they haven't. So maybe some of those exhibits overlap with what you plan on showing. Now, the last one is entitled to best estimate, and we'll get a little bit more into this, but there's a whole host of other admonitions you're going to want to go through, that they're where they're under the penalty of perjury, sworn to tell the truth, of course. But I feel like this best estimate one is a great tool for newer attorneys to use when they maybe get stuck or jumbled up with the witness who gives a lot of I don't knows. And we'll kind of go over in more detail the best practice of using this admonition, this best estimate tool to kind of dig deeper and get through some testimony. All right, here we kind of just went over this, but it outlines what I was saying regarding the objections. One other thing to highlight, speaking objections are improper. It falls also under the Stewart versus Colonial Western case. So you might have, a veteran opposing counsel who is speaking through their objections, saying, "I detest your, I detest your, I detest your definition of employee relationship, and that's not relevant and prejudicial to my client." Blah 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 blah. That's all great. But really, the purpose of objections are to preserve the record as to form the question objections. And anytime you have counsel speaking at you, their objections, again, we're not going to want to argue with them. It's just going to muddy up the record even more. Best practice, I think, is to just remind them, counsel, appreciate your objections. However, speaking objections are improper. I'd like to continue my deposition. Again, relevance, not a basis to instruct not to answer. It has to be privacy or privilege. So, whether it's attorney-client privilege, work product privilege, or some other codified privilege or statutory privilege, those are really the only grounds not to instruct a witness not to answer. And again, in the cases where counsel does instruct their witness not to answer, you're always going to want to follow up with the witness and say, are you choosing your counsel's advice not to answer, or is it for some other reason? Again, we just want to move forward, keep it going. Let's not try to get hung up on things and argue on the record. But you're always creating and preserving this issue if you ever do need to bring a motion to compel. Okay. And again, as I was kind of referring to earlier, using the best estimate tool, it's great to explain at the outset where you explain to the witness, do you understand the difference between an estimate and a guess? You might give an example where, the classic lawyer one is where you could provide me with an estimate of how wide your table is, right? Yeah, 3 to 4 feet probably. Okay, but you've never seen my table. You couldn't give a best estimate as to the width of my table. That would be purely a guess. That's an example people use. Okay, but it's good to remind them that all the testimony they're here to give today to you is you're entitled to all of it, absent a guess. You don't want them guessing, but you're entitled to their best estimate, their sworn testimony under oath they're entitled to give you their best estimate. And if they purely don't know, that's one thing. But if they have any basis to estimate, approximate, or give some sort of range to you, you're entitled to it. And so it might come up midway through the deposition where, you're getting a lot of I don't know. It's like, I don't know what time it was. I don't know how far ahead the car was in front of me. And in those circumstances, it's beneficial to bring back up this tool and say, look, I understand that you're having trouble recollecting an exact thing about something that may have happened 2 years ago. But at the end of the day, I'm entitled to your best estimate. And I'm not asking you to guess, but you do have some personal knowledge as to what happened. And, if you have any sort of thing that can provide some approximation, I'm entitled to it. And so even if you don't know the exact time, I'm entitled to whether it's between 12:30 and 1 p.m. or whether that car ahead of you was 5 to 10 feet. Because at the end of the day, you do have personal knowledge, you did perceive it, and uh, there is a colorable reason for you to give me that testimony. So I call that using it as a sword when you bring it up midway through the deposition, um, kind of using it to your advantage to get out some testimony when you might get stuck or might be dealing with an evasive witness. And so that kind of covers it for preparation. Again, there might be a little more to it we could have gone over in terms of the law. However, I think those are the core themes to keep in mind and to not get rattled early on if you're getting a bunch of objections or instructions not to answer. Um, but we'll get into actually deposing the witness, strategy, and kind of going into it, some of the sort of goals and things you're going to want to accomplish. Okay. So I think there's two goals when taking a deposition: fact finding and then getting sound bites or golden nuggets. And, at the end of the day, the ultimate goal is fact finding. So what we're doing is we're asking a witness how something happened or what they think someone else did or why their opinion is X or why they believe Y. Because at the end of the day, again, depositions are the big, and then at trial, it's the small, it's the narrow stuff we're going to be asking about. So that's why this is a moment to get everything you need to know that could come up at trial. And so we want to hear, we don't want to just ask leading questions or ask really targeting things. We kind of want to cover it all just to cover our bases. And so you know, for example, if we're taking the defendant driver's deposition in a motor vehicle accident, it might be best to kind of follow this outline of when asking questions. I like starting big and with an open-ended question. Have them explain you how the collision occurred in a lot of detail. And you're probably going to get a rambling response. There's going to be some stuff in there that's confusing, some stuff in there that is maybe a little inconsistent. However, it's good to get that on the record. And then from there, you're going to want to break up that testimony, confirm some of the stuff they said in that long-winded answer. Whether, yeah, he was going this speed right before the collision, and it was sunny outside, and I was just merging on the freeway when he turned left. Break that all down and get them into individual questions. Okay, it was sunny at the time of the collision. Okay, you were merging onto the freeway right before the incident. That's correct, right? And then once you kind of build all that foundational stuff from what they told you, you summarize it. Say, okay, to summarize, sir, based on your testimony, it's fair to say you were merging right before the incident. It was sunny outside. He was going this amount of speed. And then right when you turned over into his lane is when the collision occurred. Isn't that true? Once you kind of have that all painted in your record and you kind of have all that foundational stuff that he testified to, is kind of when you get into more of the juicy questions that you want to lock in that are going to help maximize your case, build your liability theory, build your damages that you can use as sound bites when you're drafting a demand letter, drafting a mediation brief, putting something before the judge. to include with depo citations, anything like that. And so that's kind of why I compartmentalize it into fact finding first. And then kind of once you have the foundational stuff, kind of go in, try to get the kill, try to get, okay, he did have the right of way. Isn't that right? Okay. You did fail to yield to his right of way. Isn't that true? And if you could get those, great, because at the end of the day, that's going to add a lot of value. Okay. So again, we talked about compiling exhibits. Now, using them in deposition is great. It's great for new attorneys too. I love using them because it helps keep my questions on track, kind of helps me keeps the issues in mind, break things down. It also has a practical purpose in terms of laying foundation, in terms of getting things admitted at a later date. And uh, one thing that might be a little overlooked for newer attorneys is when and how to use them during the deposition. For instance, we'll kind of go through an example here in a second, but it's also good when compiling them and maybe preparing your outline that you think about the structure of, oh, I'm going to make sure I show this exhibit with this statement before I show this one, just to see what he says about this before I show him this. Okay, here's a whole gambit of exhibits. But again, as I was kind of saying, great for authentication purposes, like foundation. Um, for instance, if you have some sort of business record, it's always great to look up the evidence code section to get that record in. For instance, a business record exception, because what you're going to want to do is you're going to look at those elements and you're going to ask, hey, is this record normally prepared in the regular course of your business? Is this isn't some sort of one-off record, right? Okay. The custodian who prepares this is who? They're going to get all that information out. So when it comes time, at the time of trial, you have laid the foundation through this depo testimony. And again, think about when compiling the exhibit, what's the purpose of it? How are you going to use it? Is this something strictly for impeachment? Is this to get clarification on what the witness thinks about how something happened, or something else? It's all great to keep in the back of your mind. Okay. Now we're gonna watch a video to kind of help flesh out this notion of using exhibits. Now, this is a case where there is a truck, a tractor trailer making a turn at an intersection, but from the middle lane. And essentially, what happens when he's making the turn from the middle lane, a car on the right comes and tries to speed past. And it leads to two pedestrians getting struck by the car trying to pass the right turning truck. Now, we're going to see through some of the testimony of the defendant driver how to use this video along with his statements in the traffic collision report and other sorts of exhibits and how it kind of plays out and how to deal with an adverse witness. So I'll play the video one moment. It's a horrible video. And going into the deposition, you're gonna taking a deposition of a driver in a video like there's clear fault. You never really know how that witness is going to handle seeing that or being asked questions about it. Um, for instance, as we'll see in this deposition, the driver of the truck thought he was completely in the right, and that's how that turn had been made. So before taking that deposition, you can just show that video right out the gate. However, I think the best practice is get their understanding of what happened, what went down, what they thought they did right, what they thought others did wrong, and then you kind of get into the exhibits, their statements, the video, etc. So first, I have a traffic collision report with that driver statement. Okay. Now, when showing someone a report where they gave a statement, for instance, or told someone X and it was written down, whether it's a police officer they told it to or some other agency, you're always going to want to ask, is what you said, is that statement you gave truthful, honest, and accurate? Okay, you're going to want to lock them in to what they said. Okay, so what you told the officer was honest, accurate, and truthful, correct? Of course. All right. And then, after laying some other foundation, you bring up this statement and you're going to want to ask if he agrees with that statement that was prepared in the report. Not sure why the highlight is blocking out the critical part of the statement. However, his statement was he was traveling between the number one and number two lanes. You're going to read that prior to your deposition, prior to taking his deposition, and think, well, I watched the video. None of his vehicle was in that far right lane. It was solely in uh, that middle lane. Okay, so ask a follow-up after. You're going to read in the statement, ask if he agrees. Okay, and then follow up with him. Do you agree with that statement that you operated your vehicle between the number one and number two lane prior to making your turn? Yes. Clean admission. Now you're going to want to show him the video. You kind of locked him in, show him the video, and you're going to walk through it with him. Okay? For instance, no part of your vehicle at 0 seconds is in its frame is in the far right lane, correct? Correct. And then, okay, at 2 seconds, when you're beginning making your turn, still you've entered the intersection, but none of your vehicle is in the far right lane, right? Keep walking it through because this goes to how he's going to present at trial, his credibility, and all these other issues, and kind of narrows down what actually happened. So when using video exhibits, kind of as I was saying, you're always going to want to pull up the video, state how long it is. This is a 22-second video, marking it as Exhibit 7. Okay. You're going to play it through once, let the witness watch it, explain to him, you play this through once, then ask you some questions afterwards. After that, you'll probably ask some foundational questions like, sir, that's your truck, right? This appears to be the intersection where the collision occurred, right? You have no doubt this is a video of the collision, correct? And then again, you're going to want to play and pause, then question. Play, pause, question. As I was saying, at this point in the intersection, you're making the turn, the light was yellow, right? By the time the collision happened, you still hadn't cleared the intersection, correct? Correct. Now, I was just giving you, example questions and testimony, but I'll tell you, it's not a clean record. And that's something we haven't really talked about is the ultimate goal of taking the deposition is not winning the deposition or making the witness mad and angry and giving you great statements. The real goal is getting a clean record that you can cleanly use in the future, whether it's playing it at trial or, like I said, using it in a demand letter or mediation brief or something like that. You don't want a bunch of questions with long rambling answers that aren't responsive. You want a clean yes or no answer or something of the sort. And it might be tricky when you have a witness who's adverse to you and is not giving you those sound bites or that clean record. So if you're here, this is some testimony regarding that video. And at this moment, you have not began your turn, right? And then he says something, of course I started, but one has to be careful, blah, 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 blah. That wasn't responsive to the question. It was actually not even answering the question how I thought he would. I'm showing him a picture of a still frame of him not in the intersection. He said he already started his turn. Then you kind of just got to prime them and remind them and say, that wasn't my question, sir. I'm just asking you about what we're looking at. At this point, you don't see your tractor trailer beginning its turn yet, correct? Then he says, if you want me to answer, that's correct. Okay, not a clean yes or no, but there's only so much digging you can really do to get a clean record. However, opposing counsel hated that response, hated when he said, if you want me to answer. As you can see, he gives a long-winded instruction to the witness, telling him that he can't just answer something just because he thinks that's what I want the answer to be. Um, and, it's kind of uncomfortable to deal with when you have counsel interjecting like that. And the witness is obviously listening to him. And that's really important to take note of because you're going to have to take back control in those situations. Because from there on out, the witness isn't going to be listening to you and thinking it's your deposition. They're going to be listening to their attorney and not answering questions as they would if they weren't giving them such coaching. Uh, so in these scenarios, it may be proper to tell counsel, I appreciate your interjection, but no witness coaching, please. This is my deposition and I'll conduct it as I see fit. And then you're going to instruct to the witness. Well, so I'll circle back to that. The witness then, after that, after hearing his counsel's instruction, he says, no, I cannot answer that question, and I can't answer any of the questions I've been asked. Well, that could destroy your whole, prior testimony you got from him and muddy it up and do the opposite of making a clean record, for instance. So in this circumstance, you kind of have to rein it back in and say, look, sir, are you saying you can't answer my questions because your counsel is implying you shouldn't answer them or because you don't understand them? Because at the end of the day, if he understands the questions and he gives you answers, those are proper responses. Now, if he's saying he didn't understand any of my prior questions, that's a different story. And he didn't really even answer that last question of whether uh, he was following his counsel's advice. He just says no because of the way one drives for safety and security, one can't answer those questions. And then again, you want it clean. Sir, you understand the questions I've been asking you. I understand. Okay. Then you kind of move on. You give them a speech. Look, I'm entitled to your best testimony, your most honest testimony, and everything you can recollect and testify to based on your personal knowledge. I ask that you give me responsive questions so we don't have to suspend this deposition and come back another day and remind them of those ground rules that you set forth at the beginning. And this is one of those instances where you follow up with them with using that as munitions as a sword versus a shield. And then this kind of just illustrates what I was just talking about. You kind of give them a little speech of that you're entitled to their best testimony. And if they know, they're supposed to give you answers. We don't want guesses. But what I'm showing you, a video of the collision and asking you very simple, basic questions, I'm entitled to your testimony that are responsive to my questions. And when they keep giving you answers that aren't responsive, that aren't maybe clean yes or no's, is when you kind of have to do some witness control and use techniques like, okay, my question is thanks, or I appreciate your response, but yes or no, you didn't begin your turn at this moment. Now, another type of exhibit, always great to use, are rules, whether they're training manuals, policy handbooks, vehicle code sections, um, commercial driver handbooks, anything like that. These are great exhibits to use once you've already kind of talked about the collision, maybe got their story out about what happened, um, after showing the video of what happened. It's great to maybe pull up any relevant code sections, handbooks, or policies that you can then ask the witness on. So for instance, referring back to this case, he was a truck driver, a commercial truck driver. All commercial truck drivers, have to get a specialized license and review this commercial handbook. Um, and so before the deposition, I reviewed this handbook, control F, making right turns, kind of the safety practices and rules that instruct commercial drivers on how to perform those turns, where their wheels should be during making the turn, etc. And so again, these are great tools to use because you're going to pull up any relevant section in this handbook, read it to them, ask if they understand it, and then ask follow-up questions if they acted in accordance with the rules that they were aware of. And whether they're aware of the handbook or not is also great testimony, because if they don't know about the commercial handbook and they're a commercial driver, that looks bad too. And just to lay some foundation with them, you're going to say, sir, you had to get a specialized license to drive the truck you were driving on the date of the accident, right? Right. You even had to take a test, correct? You had to review the commercial driver handbook, right? And you remember reviewing that handbook, and you did review that handbook. Okay. And you agreed those are the rules of the road when operating your commercial truck, correct? Then you're going to pull up the exhibit, mark it, and then go to your relevant section that you've already pulled, and then kind of highlight what you're going to read to them and ask them follow-up questions. Now, in this case example, the driver was very hostile, thinking that the Camry that was on the right lane was trying to pass him, and that he was completely at fault. Now, this code section was right on the money, or excuse me, this rule in the handbook was right on the money, because it even warns that drivers should keep the back end of their vehicle as close to the curb as possible, because this will avoid, other cars on the right giving them an opportunity to try to pass them. And this is great foundation for them to kind of get more testimony to clarify whether they think what they did was correct in accordance with this rule section or something different. Okay. Now, we kind of went through some of the goals of the deposition, strategy with using exhibits, and kind of how to handle maybe an evasive witness, some techniques, how to rein in control with counsel, stuff like that. That's all pretty good general stuff uh, to keep in mind. Something that might be a little more also beneficial to keep in mind is the words you use when phrasing your questions, the art of word choice. Uh, Now, I think it's really important, especially when you're trying to get those sound bites and that clean record, of asking questions with the right language. Because obviously, there's some words that may detract from your theory of the case, while other words can be supplemented to enhance your theory of the case. So I call it phrasing your questions with intent. For instance, plaintiff's attorney. I don't call uh, a motor vehicle accident an accident. I always call it a collision. In the depot, at the time of the collision, where were you looking? At the time of the collision, how fast were you going? Okay. And the reason we want to do this is because we want to think about our audience. Who is this? Who's going to read this depot? Is a mediator going to read this in my brief? Do I want to say incident versus collision? Or rather have the mediator here or see collision? Or if it's being shown to a jury for maybe impeachment purposes or just being played at trial, I want to ingrain and have them appreciate the seriousness of this event. So it's really important pre-depo to kind of get these use this wordsmithing technique with some of those key crucial questions you're going to ask, because those are going to be your golden nugget sound bites. And I just have, a slide with just some basic words, plaintiff-oriented words that I try to keep in mind when thinking of my questions. For instance, if I'm referring to an injury someone suffered, I would call it a catastrophic injury, assuming it is a catastrophic injury, such as a very severe fracture or amputation. I try to sprinkle in these words when asking questions that have yes or no answers. Like, you agree this was a life-altering event, correct? Correct. You agree, if you're asking your doctor, you agree he will suffer from a permanent impairment in his leg, right? These all kind of enhance the type of nature of the words, or excuse me, these really enhance the way these sound bites come off because it gives them more teeth. And I have down here KC 3905, which is our pain and suffering instruction, and it lists all the different types of items of harm that one is compensable for, such as inconvenience, loss of enjoyment of life, mental suffering, disfigurement, humiliation, grief, anxiety. All those are listed in that instruction. And because those are technically um, items of damages to your pain and suffering component, to your non-economic damages, it's great when you can get testimony that have clear sound bites of uh, you agree he's experiencing loss of enjoyment of life because he can no longer walk, right? You agree that his finger is disfigured after it got fractured, correct? You agree that it's very inconvenient for him that he can no longer mobilize himself to the bathroom. Now, what we're basically doing is we're matching evidence to elements. That's kind of what it's all about at the end of the day and what you're going to want to prove at trial. And kind of following up on that on damages, because we really think, I feel like, a lot about liability and getting a lot of liability emissions and stuff like that. Don't underestimate the type of testimony you can get with respect to damages. Even if it's a liability witness, even if you're taking the defendant driver's deposition, there's a chance you can get some great damages testimony. You just have to try. And I have a bunch of examples here of uh, how you can do it and how it can even be used in a very strategic way. For instance, in this last case we've already been talking about, always ask, you'd characterize this as a catastrophic collision, right? She gives kind of a weird response that doesn't really respond to the severity of this collision. Okay. Kind of gotta walk them through it, follow them back through, and just say, I probably said, look, someone got struck, a pedestrian got struck by a vehicle, right? Right. And kind of walk them through, follow back up with a clean question, say, my question is this was a severely catastrophic event. If anybody's hit, even if it's light, I'd consider it catastrophic and horrific. Wasn't a clean yes, but we'll take it in this instance because at the end of the day, in your mediation brief or in your demand letter, you're just going to say, look, the defendant driver, the other party even agrees that what happened here today or what happened on the date of that collision was a catastrophe. State the depot. Okay, I have a clip here of kind of evoking damage testimonies, and this is a case where a bus collided with a center divider. Um, right here we have the bus driver being deposed, and this is my boss conducting the deposition. However, uh, it not only illustrates getting damages testimony from a liability witness, but also kind of handling a witness that isn't going to give you, yes, this was a severely catastrophic event, or yes, this bus is severely damaged. Hopefully this hopefully this sound plays. Might take a second to load. But you're going to want to show them exhibit. You're going to want to show them this bus picture. Hold on. I'm not hearing it. Stop sharing 1 second. Okay, I'm having an audio issue, but I'll give you the rundown. Basically, asking him, look, you characterize this as an impact with major damage, right? He goes, it's damaged. He goes, no, my question is, looking at this bus with a smashed window in, this constitutes major damage, right, sir? I mean, it looks damaged. Then you ask him some follow-up questions. Sir, you're an experienced bus driver, right? Yes, okay. And, you know, this isn't a minor collision. You would agree, right? And you might say, well, I don't know. It depends on who you ask. Well, I'm asking you. And there are people injured to your knowledge in this bus, right? Yes. There was a window smashed in. The A-frame's bent, correct? Looking at this image, we see the entrance all disfigured, correct? Okay. Are you saying you don't consider what we see in this picture, this damaged bus, to be major severe damage? He may give it to you, he may not. If he doesn't give it to you, that's fine, move on. He kind of looks, not like the most credible person, not agreeing this is some significant damage. Okay, hopefully this sound works. If it doesn't, uh, I'll just explain it away. So this kind of goes along the lines of taking treater depositions, first responder depositions, like paramedics, because in these depositions, they're kind of methodical and a lot of times boring, especially taking a paramedic's deposition. Uh, a lot of times when you take a paramedic deposition, they don't even remember what they responded to, why they're even there. They're really just gonna kind of look at their report and answer some questions based on that. Other than that, uh, it's kind of hard to get a lot out of them. That's really beneficial. It's great for foundational stuff, sure, but when it comes to kind of maximizing your case and using some sound bites, it could be difficult at times. I feel like a good way to kind of prime your witness, whether it's a paramedic, a firefighter, or someone who was at the scene looking at your client, treating them, a good thing to do is to show them exhibits first before asking those kind of tight questions about this person looked like he was in severe pain, right? The person you were treating was clearly suffering, correct? It's hard to ask those questions to them if they don't remember. It's best if you have body worn footage to show them responding to the person, hearing them scream, hearing them, hearing or seeing the type of bruising or abrasions on them. Showing them that jogs their memory and makes them more flexible into giving you those clean admissions. So, like in here in this case, walking through with the paramedic, this was a case where a pedestrian got struck by a car making a right turn or left turn onto a one-way. And it was a really horrific event. However, the paramedic had no independent recollection of this scene in treating this patient. So walk through with him the body worn footage, pointing him out. Say, sir, that's you, right? That looks like you. Yes. Okay. And we see here a person being put on a stretcher, right? Yeah. You hear them screaming, correct? Yeah, I hear them screaming in the video. Then you walk through the patient care report where it says this person was reporting level 10 pain at this point. This person reported this level pain at this point. This person required critical care and treatment. Once you walk through all that with them, they kind of have a clear understanding of what actually happened. Maybe they remember little bits and pieces, but at the end of the day, you're going to finish off that depot with a set of damages questions saying, sir, the person you were treating was in a severely catastrophic condition, right? He was traumatically injured, correct? He needed critical emergency care, yes? And those you might not always get, but you'll have a better shot if you're showing the witness more to help them kind of grasp what they remember, what actually happened, and the severity of what happened. We'll see if this plays with sound. Hopefully it does. So I was showing him this body worn footage and then asking him questions. This is the paramedic. I don't think you can hear it, but again, asking those questions, traumatically injured, severely catastrophic. Yes, yes, yes. Got all of those. It's great. This is another way to kind of get good damages testimony out of a paramedic or someone who doesn't really remember what happened is going through the report prior to the deposition and then highlighting things that are very favorable to your case. And even though they may not remember that that's what happened to that patient or that client, have them explain that because you're going to get really good testimony and you can use that in various ways. Again, I don't know if the video is going to play here, but essentially asking, I saw in the report prior to this deposition that the ER doctor, not even this witness, the ER doctor said in the narrative of the patient care report that the client's liver was mashed. That's, kind of an atypical way to phrase some medical trauma. So I asked him in your own words, based on your understanding of, based on your experience and training, how would you explain to someone when you hear that a liver is mashed? He goes on and on about what that entails and, how severe it must have been for an ER doctor to say and use that word, mashed. Let me go back 1 second. Okay, you didn't see it in that video, but what was so great about uh having that paramedic, that life flight paramedic, he was actually the one who transported the patient from one critical care facility in Eureka all the way to UC Davis and was with them the whole time, is that we actually used that testimony in a mediation video. We made an entire about 22-minute long video for mediation purposes where we had animations of the accident. We had surgical animations of the urethral repair and the pelvic fracture being repaired with the screws and plates, the ankle fracture, the liver being lacerated. And yeah, it's great to have an animation, but it's great when you have the treaters talking about it with sworn testimony to overlay on those animations. And so if you do have something coming up like a mediation date, maybe a demand you want to get out, or a video you want to make, it's kind of great to keep that in mind when you have these depots noticed and you have them upcoming to think about, I want to get some testimony about him talking about this type of injury and ask it in this way so I can play it over this animation or so I can include it in the demand letter to really hammer this issue. Uh, because at the end of the day, you can use this testimony in a variety of ways, whether it's for a video, mediation video, whether it's in a motion, a day in the life video, anything like that. Uh, so while we're fact finding at the end of the day, and that should be like the overarching goal of getting the story of what happened or what they think about this, getting these clean record sound bites can serve a lot of purpose on the back end too, uh, in other ways than just that trial. So I just have here some important takeaways regarding, the importance of damages testimony other than just liability is like I was saying, think and plan ahead. Like if you have something coming up or you want to make a mediation video or you want to make a demand letter, uh, really spelling out the damages or really spelling out that, hey, the other side doesn't think what happened here was a big deal. I need to get some testimony. This was a big deal. And this was a severe event. This was a catastrophic collision. Keep that in mind when you're taking these depositions because this could help you in the future. Wordsmith maximizes sound bites, as we talked about, accident versus collision, um, uh, catastrophe, trauma, life altering, upending, using those KC elements, loss of enjoyment of life, pain and suffering, disfigurement, and then, there'll be times where you're kind of going and it feels a little awkward to ask these sort of questions. Um, and you might get awkward responses. That's okay. It's better to ask than to, down the road being like, I wish I did just try that out. Even if you don't get anything or the witness looks at you weird, it's okay. We just move on. It's a long deposition anyway. You should really try to push yourself to try things and to evoke testimony that could be favorable to your case. Because at the end of the day, you might be really close, even if you just ask another follow-up question to an evasive answer from getting a real golden nugget that you can use, or a really good admission, or a really clean soundbite. Now, once you finish, you take your deposition. For new attorneys, it's really important to review the transcript. You're going to get that transcript back. You're going to want to mark it up, get different pens, highlighters, colors. I strike my filler words. I say and a lot or okay before asking a question. And at the end of the day, the goal is a clean record. Um, so it's really good to put pen to paper, striking that out because it keeps in the back of your mind for the future to not use those words. And then in other instances, maybe see where some of your questions were a little off or a little funky and see when the witness might have given you something that you should have followed up on. A lot of times we're not listening or thinking about our next question. I'm victim to it and it happens all the time. And that's why it's really important to see and listen what the witness gives you because they might have given you something great. And if you followed up on it, you caught it, uh, you really don't know what you're missing out on. So learn from those mistakes. I mean, it's all about reps. It's just about doing it. You kind of learn through every deposition. Sometimes you have an awful one, sometimes you have a good one. And there's a 99% chance it's never going to see the light of day anyway or be played at trial. So we just kind of move on, keep getting those reps in, and hopefully this gives a little more uh, some tools and insights of taking depositions for new attorneys. All right. And that concludes it.
All right, Tyler, we do have quite a few questions if you'd like to
Yeah.
get into. Starting off early on, Christopher Rose asked, how do you feel about a short depo dialed into key points and not running all day just to verify already sworn testimony and discovery?
Yeah, I think that's great. I think sometimes, we spend a little too much time wasting time on overexpansive depositions. And at the end of the day, it's really just what you want to get out of it. If you know that's really all you need for a short depo just to verify discovery. For instance, if you get some responses and maybe there's some hesitation into whether those are actually um, what the party is portraying happened, it might be fruitful to take a short locked-in deposition. Yeah, I don't see any issue with that.
All right, and Heather asks, is it proper to use a prior transcript from the same witness example, a PMK from a company to challenge credibility of a witness, and a separate case concerning the same corporation?
It's proper. However, again, kind of going back to strategizing how you want to use your deposit or you want to use your exhibits. So using that prior transcript, for instance, maybe for some impeachment that might come up during the depo, maybe it's fruitful to not show that and save it for trial. Have them locked into one thing, and then in the trial, you'd show the prior transcript, get it introduced, and challenge credibility that way. Or if you think it would be beneficial to bring up during the deposition, perfectly good. It's a prior sworn statement of the witness, so it would be proper.
Christopher Rose asks, why don't you use crash instead of collision?
Crash is good. Crash just might be just as good as collision. I like that. I'll use that.
All right, and let's see. Shireen requests if you can give some tips on effectively dealing with hostile, harassing, opposing counsel and constant speaking, objections, and coaching.
Yes. So in terms of dealing, I mean, I'm kind of, a younger baby attorney, and a lot of times I'll get opposing counsel on this other side that's a veteran and tells me they've been practicing law for X amount of years and they're giving a lot of speaking objections and witness coaching. I found personally best practice is to not engage them as much as possible. And what I mean by that, with one simple statement, kind of be a little passive with them. Counsel, I appreciate your speaking objections, which are not proper. However, I would just like to conduct my deposition, and I appreciate you not doing that. Otherwise, we might have to suspend this deposition because you don't want to be fighting back and forth with them on the record. And the reason that is because if it ends up going to a judge where there's a motion to compel testimony, that judge is not only going to read harassing opposing counsel, but they're going to see you fighting back with them and giving them fuel. So it's just kind of politely remind them that it's improper, and hopefully they kind of puts them in their place that, hey, this lawyer knows that what I'm doing is a little overboard, and hopefully they settle down.
All right, and I have another question. Jean asks, what do you say to cut out, oh, when you say to cut out okay and other words, can you do that with what you turn in and use in court as the transcript?
I would caution against that. For instance, I assume you mean like if you were to play it at trial or something, or maybe put it before a judge, whether it's an emotion or attached to a motion. I think you really do want to put exactly what was said down, just so there's no speculation from the other side that there might have been um, some foul play. So at the end of the day, you can cut it out if it's maybe some informal, letter or something. But I think best practice is you kind of got to copy and paste the exact question, exact answer.
All right, thank you. And let's see, we have quite a few more questions. What suggestion do you have when a depo is limited to 2 hours I guess in this case it was a California lemon law case, and the witness is being evasive and or wasting time with unresponsive answers?
So in that circumstance, I would again kind of refer back to your toolbox of what you're entitled to, and you're entitled to his best, most honest testimony. And if he's still giving you a lot of evasive questions, you got to remind him of the time deadline, or excuse me, you got to remind the witness the time deadline. Look, I only have you here for 2 hours. This is my chance to get your testimony. My question is this. If they're still giving you evasive, sir, yes or no, XYZ, still giving you really evasive responses after all that and not being straightforward with you, you can caution them. I might have to go to the judge and compel you to be deposed again for an extended amount of time because you're not giving me what I'm entitled to. And hopefully that speeds things up and gets you through it on time.
All right. And Kaz asks, how do you balance getting good deposition testimony versus alerting the other side to weaknesses they can fix for trial?
That's a good question. You know, I think it really goes into planning before the deposition of kind of what you want to signal to the other side. For instance, like, do you really want to signal your theory about um, maybe some code violation that they're not aware of and ask them about that during the deposition? Or do you want to kind of save that for trial? Again, I think at the end of the day, this is just my own personal opinion. It's kind of better to get everything out there in deposition. So, you have some sort of format for trial because when you put that witness on the stand, you're going to want to know what they're going to say. And so if you're saving something and this is your chance to depose them and find out what they think about it, they might give you something completely off the wall at trial and you have no record or prior testimony from them to impeach with. So it's really a strategy question. And at the end of the day, if you're signaling it to the other side, I don't think that's a bad thing either. It's like you kind of want them to know your theory and what you're running with in most circumstances so they can properly evaluate your case when you're making your demands.
All right, thank you. And we have a couple more here. How can you properly admit deposition testimony in the context of a trial for impeachment purposes?
So, well, if it's for impeachment purposes, it doesn't have to be per se admissible, right? But if we're trying to get it admitted uh, for its truth, for instance, okay, um, you're gonna have to, well, one, is it a party whose deposition you took? Two, it's also a witness that you ask questions under oath to, okay? And, under the code, you're allowed to designate deposition testimony for the time of trial. We have the code section. I think it's 20, don't quote me on this, don't rely on this, 2025.620 subsections. Don't correct me if I'm wrong. But so when you notice your deposition, you're noticing the intent to play it at trial, which comes in for its truth, absent any objections that are ruled upon by the judge prior to trial. So it's good in your notice to include that if you do think this is something you're going to use at trial. But I'll give a quick thing for impeachment purposes. You would honestly just the judge is going to have a binder of all the depositions in that case, pretty much, and assuming that witness's depositions in that binder, along with counsel having a copy of it, you're going to say to the witness, "Sir, you recall taking a deposition on this date and time, right? What you told me was the truth. You knew you were sworn under the penalty of perjury." And then you're going to ask the court to read from their depo transcript for impeachment. And uh, and then that's how it would work.
All right, so we have two final questions. Jeff Thomas asks, when is it appropriate to read into the record or ask witnesses to read a document into the record?
Yeah, it's a good question. I don't know if there's a per se guideline on reading in versus having the witness read it. I kind of do it based on preference. If it's a really long narrative section, for instance, I'll have them read it to themselves, ask them afterwards, do you finish reading? Do you understand what you read? And then ask questions. But for instance, if it's like a tight code section or maybe a small statement, I'll read it into the record. Um, just if I really want a good snippet of what we're talking about. So, like for instance, if it's a tight vehicle code section of, um, you know, drivers making a left-hand turn without a solid arrow, have the duty to yield oncoming traffic before making that turn. I'll probably just read that into the record and then ask if they understand that, they're familiar with that rule, then ask my questions. So we have kind of a clean record of what we're talking about, what the rule is, that they know that rule, and then that they didn't follow it.
Great. And then final question from Shannon. Suspending deposition is more extreme of a remedy. At what point is it necessary? Tips to help getting a hold of the depo before it gets to that point?
Yeah, great question. Yeah, that really is the last resort, and hopefully it doesn't come to that. Uh, Again, the tips are, you know, being as patient as possible with maybe a harassing opposing counsel or an evasive witness. If it's a witness who is just being completely evasive and kind of being a weasel and not giving what you want, you kind of got to make judgment calls with them and I kind of do a 1, 2, 3 technique with my questioning where I'll ask a straightforward yes or no question and they give me something completely off the wall that's not yes or no. I say, sir, it's a yes or no question. My question is this. Again, evasive, and then say, sir, I appreciate that response. I really am just looking for a yes or no question or or a yes or no answer or an I don't know. And based on what you testified to, I'm entitled to that answer. And if they're still being evasive, you can do little other techniques where they might say yes, but XYZ, say move to strike everything after yes. And that kind of signals to them like I'm um, I'm being evasive or I'm being difficult. Those are some like little techniques. But again, if they're being really evasive the entire time, that's not a terrible thing for you because it does make them look like not a great witness. Now, when it comes to opposing counsel and handling them, I think kind of as I mentioned earlier, the best practice is to be polite. Also, be affirmative that you do know the rules of the deposition and that witness coaching is improper and that counsel, this cannot keep happening. You have to let me take my deposition. I don't want to go before a judge and have them read all of this improper, harassing comments from you. You can say stuff like that and maybe give them like a 1, 2, 3 strikes you're out type of thing or use your best judgment. But again, I would refrain from arguing on the record as much as possible and let them know when what they're doing is improper and move on.
Great. So that's all for questions today. Thank you again, Tyler, for taking the time to educate our members. And thank you so much to our audience for sharing the time with us. Have a great day, everybody.
Great. Thank you, everyone. Have a good day.